Hello, welcome to the Illinois Soybean Association's ILSoyAdvisor webinar. I am Corey Lacey, Public Policy Manager at Illinois Soybean Association. Today, Dr. Aaron Hager will be presenting Navigating a New Era, Understanding the Endangered Species Act and its Impact on Pesticide Regulation. Dr. Hager is a professor of weed science at the Department of Crop Sciences at the University of Illinois. He has more than 30 years of weed science experience and assists agronomic crop producers manage weeds by implementing sustainable practices. The focus of his research program is to develop innovative weed management approaches with an emphasis on addressing contemporary weed species infesting corn and soybean in Illinois. His ultimate research goal is to establish a robust applied research program supplemented with basic research fostered through novel collaborations with ecologists and molecular biology scientists to provide economical and sustainable solutions to fundamental weed management challenges plaguing Illinois producers. Dr. Hager's knowledge of practical weed management has been shared with weed management practitioners across US, Canada, South America, Europe, and Asia. And so just as kind of an introduction, the EPA is developing an updated endangered species work plan that addresses how the agency can protect nearly 1,700 threatened and endangered species in their critical habitats, while governing the registration, distribution, sale, and use of pesticides. To comply with the ESA, the EPA will evaluate the potential effects of pesticides on federally threatened and endangered species and their critical habitats, and then recommend mitigation strategies developed in partnership with other federal agencies. Examples of this include requirements for vegetative filter strips, field borders, and grassed waterways, terracing, contour farming, cover cropping, mulching, and adoption of no tillage or reduced tillage strategies, and the safe disposal of excess seeds that have been treated with pesticides. Once finalized, such protections will become part of the formal registration review process for various geographic regions and for various groups of herbicides, insecticides, and fungicides. The Illinois Soybean Association urges farmers, applicators, researchers, and agronomists to become more familiar with the Endangered Species Act, ESA, and how the EPA proposes to meet the agency's requirements when registering or re-registering pesticides. This webinar is being recorded, and the recording, as well as more information on this topic and other ISA-funded research projects, can be found at ILSoyAdvisor.com. Questions can be submitted through the webinar Q&A and will be addressed at the conclusion of this presentation. Additionally, as part of our Q&A session, Kyle Kunkler, Director of Government Affairs at the American Soybean Association and responsible for pesticide policy issues, will be available. Kyle will be a great additional resource to offer policy and DC perspective during the Q&A, and we thank him for his participation. Finally, one CEU and integrated pest management is available for certified crop advisors. A QR code will be provided at the end of the presentation. At this time, I'll mute, and Dr. Hager, you can take over.
All right. Well, Corey, thank you very much for that introduction, and extend my thanks and appreciation to all who are participating here this morning. Now, before we actually get into the presentation, I guess we'll call this the Hager disclaimer, so to speak. Just really want to emphasize here at the outset, much of what we're going to discuss today includes these proposals of how the U.S. Environmental Protection Agency will implement changes in pesticide use to meet the agency's responsibilities under the Endangered Species Act. And I italicize the word proposals because right now I think that's exactly how many of these actually exist in the proposal form. I don't think there's really been anything that has been set in concrete or stone as of yet. And it is possible, of course, that some of these could actually change between the conversation that we are having here today and ultimately whenever these proposals are actually implemented. And secondly, what we'll talk about this morning, quite honestly, folks, this represents my best understanding of these proposals. I typically remind myself, as my wife does on numerous occasions, that I am the perfect example of imperfection. In other words, I am fallible. And some of what we talk about here today, if I've made any errors or any mistakes, I would certainly appreciate someone pointing these out, and we'll try to get these corrected as we move forward. And so we've actually had several conversations around the state of Illinois with different groups, different organizations, whether these be agencies, agricultural organizations, or even farmer retail applicator meetings, about where we think some of these changes are going to occur with respect to how pesticides are going to be used moving forward here, not only in the state of Illinois, but across, for example, the Midwest and all agricultural production areas that rely on pesticides. And when I start the presentation, I usually start out with a question. Now, I understand that many times that's probably not the most appropriate thing to do, to start with a question, but we do it anyway. And the first question that I'll ask every audience is simply, has anyone either used in the past or used in the current season or plans to use in the future either Enlist 1 or Enlist Duo herbicides on some of these Enlist treated varieties? And of course, you'll have a lot of other questions, or a lot of people who are raising their hands and saying, yes, we do understand. We have done this before, this, that, and the other. But then I'll actually follow up with the next question. And that is, let's see. Well, I think I've lost the ability. There we go. And then the follow-up question is this. I'm curious to ask, which of these label mandated runoff mitigation practices did you use or do you plan to use based on the soil hydrologic route to obtain 4 or 6 credits? And unfortunately, the response that we get to this is much less receptive than the response that we get after we've asked folks, have you used this technology? As a matter of fact, I hate to say this, but in many cases, this comes as a surprise to the audience about knowing that these are now label mandated practices on these particular product labels. And so the thesis statement that we have developed and what we're really trying to do with these conversations that we're having is simply raise the awareness of users of agricultural pesticides. And our thesis statement is that how we are going to use these products in Illinois, for example, is going to become more complex as we move forward. And we describe complexity in terms of changes in labels, more complex labels. So what must an applicator do in addition to what we refer to as the traditional practices? Certainly, we look at labels for application rates, for volumes of application, for nozzle types, for example, weed sizes, application timings, restrictions, etc. But there's probably going to be more as we move forward, as we just saw in the previous example, that we're going to have to pay attention to, be aware of some of these changes, new additions to product labels. More than likely, we suspect there's going to be more record-keeping requirements. And this is not necessarily a bad thing, for example, because records are a good thing to have if you happen to encounter a pesticide misuse complaint that's filed against you. We'll see more complex regulations, of course, on labels, and we already have seen some of these. For example, where can this product be applied? Where can it not be applied? Are some of these restrictions at the county level? Are some of these restrictions going to be on the actual range of a threatened or endangered species? These are really things that we haven't really dealt with a lot in the past. Can you actually make the application of this particular pesticide if pollinators are visiting the treatment area? And exactly what does visiting the treatment area really mean? I guess I'm not exactly clear. I understand what that is. And then certainly this could trickle down even to more complex misuse investigation. And of course, my understanding would be that if these practices, if these mandates do appear on the federal label, these are, for example, these pick list practices become enforceable by the Illinois Department of Agriculture. And one question that I'll throw out right now that I really don't have a lot of clarity on, and we'll come back to this toward the end, who exactly is responsible for implementing these mitigation or these pick list practices? And so I guess it really begs the question, what is driving all these changes in how the US EPA is handling pesticide registrations, re-registrations, et cetera, in how we're going to use pesticides moving forward? And the answer, I think, is fairly simple and fairly clear cut. It's really the United States Environmental Protection Agency working within the mandates of the Endangered Species Act. So we'll slow down a little bit and we'll ask the following question. That is, of course, what is the role of the US EPA in pesticide regulations, pesticide registrations, and how are these registrations going to potentially be impacted by the ESA? And so the regulatory framework within the pesticide registration and use process really hinges around a couple of important documents. Of course, number one, of course, is what we call the FIFRA, the 1972 Act known as the Federal Insecticide, Fungicide, and Rodenticide Act. This is an act that is administered by the U.S. Environmental Protection Agency, particularly the Office of Pesticide Program. And the purpose of FIFRA, of course, is the regulation of pesticide products, the regulation of the registration of these products, and the regulation of how these products are ultimately used at the field level. And one thing that we always emphasize about FIFRA, and that is that it is a risk-benefit statute. So in other words, within FIFRA, there's the phrase, no adverse, unreasonable effects on the environment. And that certainly is something that we strive for in production agriculture. We do not really want to adversely impact the environment. But the risk-benefit analysis within FIFRA allows that, okay, if there is a risk associated with use of this product, if the benefits or the potential benefits of using this product are known to outweigh the risk of using that product, then the agency can move forward with that registration or that change in use pattern of that product. Now, the other one, of course, that comes into play in this conversation is the Endangered Species Act, an act that was passed back in 1973. Now, unlike FIFRA, that is administered by US EPA, the Endangered Species Act actually is administered by both the Fish and Wildlife Service predominantly and the National Marine Fisheries Service. The purpose, of course, of the ESA is to conserve and or recover threatened and endangered species and their habitat. And really the phrase "and their habitat" is going to become very important as we think about the reach of what these changes in registration, re-registration, and use patterns will look like moving forward. Of course, the ESA is a law that's supposed to be followed by all federal agencies. So it's not just the US EPA that has to follow the mandates of ESA. It is any federal agency that has to make sure that any of their actions do not jeopardize the population. So in other words, any action that they do is not likely to jeopardize the continued existence of this threatened or endangered species or result in the destruction or adverse modification of their habitat. And again, of their habitat is going to become very important as we consider these implications of this act. The other thing about ESA, it's really not a risk-benefit statute. It's more of a thou shalt not do this statute. So in other words, you cannot take or illegally kill one of these endangered species. So really, in difference to FIFRA, which says, okay, if there is a risk associated with this use, if the benefits outweigh the risk, we can move forward with this. ESA, on the other hand, is a document or a law that essentially says we cannot really tolerate any risks associated or to these threatened or endangered species. Now, again, the ESA was established in 1973. And again, one of the key take-homes that I really hope to emphasize today is not only are we talking about the threatened or endangered species themselves, but we cannot destroy or adversely modify any of the critical habitat of these species. So if we think about our production systems here in Illinois, for example, there's very few, if any, endangered species that I'm aware of that actually would grow in a cornfield and a soybean field that's been under agricultural production practices for decades. But there are endangered and threatened species known to exist in Illinois whose habitat, while may not be within that individual field, maybe their habitat is a half a mile away along a ditch bank or a stream bank, for example. Maybe it's a mile away, maybe it's all downstream. But that is, of course, the critical habitat of these species. And again, to really emphasize the point, if we talk about the ecological footprint of a pesticide, it's not necessarily only within the boundaries of the field in which it is applied. There are avenues where an applied pesticide can move from that treated area and potentially adverse affect either the threatened or endangered species itself and or the critical habitat of these species. And really, I think this is where a lot of the focus on what the agency is proposing to do really focuses around this off-target movement out of the treated area. And so I guess we can ask the logical question, if FIFRA has existed since 1972 and the ESA has existed in 1973, and we by and large have really not had a lot of attention paid, for example, in agricultural publications, registration decisions around the ESA. So why are we here talking about this today? And really, what's the recent focus about US EPA on meeting the requirements of the ESA? And basically, in summary, we had our last meeting of the Weed Science Society of America occurred last January and February in Arlington, Virginia. And Jake Lee, who is one of the Deputy Assistant Administrators for pesticide programs, addressed the meeting of the Weed Science Society. And during his presentation, he made the remark that essentially EPA has acknowledged that the agency has registered and re-registered pesticides essentially since the inception of FIFRA without really going through all of the requirements to satisfy ESA. So in other words, a lot of pesticides have been registered that did not follow the mandates of the Endangered Species Act. And if we look across the regulatory landscape here in the United States, arguably, I think it has shifted. We see new responsibilities under the ESA that our federal agencies now are in a position really to address. We see new policies around new active ingredients. Litigation is a big factor involved in why we are seeing these changes taking place as they are. Registration reviews, for example. I think every pesticide has about every 15 years it has to go through the re-registration cycle within the agency. And so a lot of pesticides that have been labeled for many, many years without ESA requirements, as they go through the re-registration process, ESA considerations are now going to become part of that re-registration review. And of course, we'd like to think that most all of this, of course, is based on science, but in all honesty, folks, I'm not exactly sure it all is. I'm sure there is probably some political pressure that has been in place that really is trying to drive what this is. And here's an example. This is an executive order issued from the White House in January of 2021. And within this executive order on Section 2, the executive order says, hey, we need to immediately review agency actions taken between January of 2017 and January of 2021. Why are those dates of interest? Of course, that was the previous administration. This is a mandate. This is an executive order that came from the new administration. And essentially, they are concerned about some of the actions taken during the previous administration and how these things may or may not actually be based on science or politics. Again, I get that. That's the nature of what we see in the political system here in the United States. But here's an example. This is actually from the U.S. Fish and Wildlife Service. This is a news release that was dated June 4th of 2021, in which the agency announced that they are a plan to improve and strengthen their responsibilities or the implication of the Endangered Species Act. Now, that's all fine, of course. But then, of course, they reference these actions that follow this executive order. And again, politics is something that I really believe does play a role in some of this. I'm not saying that's a good thing nor necessarily a bad thing, but we certainly hope that a lot of what is being proposed here is really based on sound and good science. So a little bit more about the Endangered Species Act. We can describe this as somewhat burdensome, or we can describe it as somewhat easy to institute litigation around. These lawsuits tend to be fairly common. There's a lot of broad provisions within the act that really allow for even citizens who may or may not have a lot of background, a lot of interest within a particular area that can say, look, we are very concerned about this one particular species that we have heard about. And so really a lot of these cases are typically more about what we call the remedy than they are the facts of the case. Now, this is kind of a very slippery interpretation of this. And of course, this is my interpretation of this. But I guess when I look at, have we ever seen a threatened or endangered species actually become extinct directly due to pesticide exposure? I'm at a loss to really come up with a lot of examples here. About the closest I can come up with would be what happened with the bald eagles decades ago around DDT. But that's really not the point here. The point is about really the remedy. This is a federal statute. The ESA is a federal statute that mandates that all federal agencies must follow this to protect these endangered species. The EPA has said that they really have not followed this to the letter of the law for many, many decades. And so now this is the implementation of how the agency is going to try to follow what these mandates are with respect to pesticide registration and use. Now, there's more than one pathway that could actually trigger an ESA evaluation and or consultation. And we have seen this already in the last several years, for example, with some traded herbicides. We gave you an example as we began the conversation here about changes to the Enlist herbicide product label that now includes provisions around endangered species. Certainly new chemistries, new active ingredients are going to fall under the auspices of the ESA considerations. Again, registration, review, reevaluation, etc. And then if there's significant new uses or amendments to existing product label, and again, the litigation around ESA continues to evolve. It's not necessarily something that we would think is static. It's certainly something that tends to be more dynamic in nature. And as of the end of last fall, at the end of October, there were just short of 1,700 species that were listed under the Endangered Species Act. And over here in the table over here to the right, you can see where these almost 1,700 species, the categories or the groups that they fall into. And if you'll notice here at the bottom, over half of these threatened or endangered species are plants. And so from a weed management standpoint, certainly is the area that I've worked in now for over 30 years, this is something that we really believe we have to pay attention to in terms of what the agency is proposing to do in order to meet the mandates of the ESA. And if we think about something like a product like glyphosate, for example, that has such broad activity against a lot of plant species, you know, we really need to pay attention to what will be something like the proposals around glyphosate once it undergoes the re-registration process with the agency. And so I guess, you know, we say, what are the challenges, I guess, with that the agencies are now facing around the ESA implementation? And really, first and foremost, the courts are ruling that the EPA must comply with the ESA. Again, the agency has said we really haven't done that since the inception of the law. And the courts are finally saying, look, you need to start doing this. Courts, obviously, they do have the statutory authority to cancel pesticide registrations. And we saw that as recently as 2020, when the Court of Appeals for the Ninth Circuit canceled the dicamba products that are registered for foliar use in dicamba-resistant soybean. Now, if I understand that ruling correctly, it did not rule exclusively that EPA had violated ESA, but again, it simply is an example of the power of the court systems to mandate the agencies follow the requirements under the Endangered Species Act. The current approach that the agency has used to try to meet these is extremely time consuming. And I believe these are estimates from the agency itself that the EPA thinks or suggests that it's going to take anywhere from 4 to 12 years for the agency to get each pesticide reviewed and or in compliance with ESA. And as a whole, the agency has said they estimate about 360 years to complete all the ESA compliance reviews for all the pesticides that are registered and regulated by the agency. And that certainly is something that is not conducive for continued registration of new active ingredients or re-registration of existing products. And so the agency, of course, has proposed different modules, different proposals to try to move forward to manage this workload in a much more time efficient way. And so we ask the following question, and we ask our audiences, have you seen impacts of ESA so far regarding crop protection products? And again, most people are at a bit of a loss at the outset to answer this question, and certainly a bit of a loss to really give any examples. But the fact is that we have here in Illinois, for example, as we moved into the 2021 growing season with the dicamba products registered for use in dicamba-resistant soybean, one of the new requirements was an additional downwind buffer. So if you actually are making an application in a county in Illinois where a threatened or endangered species is known to exist, instead of a 240-foot downwind buffer, that now is increased to a 310-foot downwind buffer, and the implementation of this 57-foot omnidirectional buffer. So this was something that we hadn't really dealt with before. We attempted to make a lot of folks aware of this early on, that in these counties, you need to go to these things like this Bulletins Live 2 to determine whether or not that application that you are scheduled to make, if it is in one of these counties, for example, you need to take some additional considerations in mind, because what you're required to do is going to be a little bit different than if you're making that application in a county that's not listed here. And another example, this is a news release from the US EPA dated December of 2020, in which the agency is proposing the registration of a new herbicide, trifludimoxazin, from BASF. And in the news release, the agency stated that this is going to be a good additional tool in managing herbicide-resistant weeds. The agency had reviewed the active ingredient and determined that there were no human health risks or concerns with registration of this product. That, of course, again, December 2020, roughly a year later, we see the issuance of the Endangered Species Act policy now for new active ingredients. And the first general question that was addressed was, when does this policy take place? And essentially, the agency said this will take place immediately. And this analysis will now include all conventional applications that are already submitted for consideration. So again, to go back to December 2020, when the agency issued the news release, we intend to register this new herbicide. Here are the new guidelines that came out roughly a year later in 2022 in January. And here was a news release that came out shortly about a month later in February of 2022, announcing that the registrant will stop selling this particular product and or not even pursue the label registration. And in the lawsuit filed by the plaintiffs, they state that the agency, that would be, of course, the US EPA, did not address the herbicide's risk to protected plants and animals as required by the ESA Act. So essentially, those are a couple of examples of where we have seen that ESA changes have now actually taken place and have affected how we're trying to manage weeds here in the state of Illinois. And another good example, and we have seen this before, is the new Enlist labels that were granted originally in 2017. They were now expanded out for a 7-year re-registration out to the year 2029. And we won't go through all of these, but a couple of things to point your attention to. We've already seen this pick list. And what this pick list is really trying to do is to implement runoff mitigation measures. And remember, we go back to the requirements of ESA. It's not just we cannot adversely affect the endangered species itself. We cannot adversely modify the critical habitat of that endangered species. And of course, one of the ways, of course, that a pesticide can move from a treated area is through runoff and or soil erosion. So the other thing that came as a bit of a surprise to a lot of people when these new labels were issued are these geographical restrictions. And if you go back to one of the earliest slides, when we talked about more complex labels, we talked about the question of whether or not a pesticide can even be applied in a given area. Now, that could be in a given county. It could be across the range of a certain threatened or endangered species. And there were several counties when these labels were actually issued by the agency where either Enlist 1 or Enlist Duo could not be applied. And there were actually several counties in the state of Oklahoma that were impacted by these new rules. So we go back to the table on the runoff mitigation practices around the Enlist 1 and the Enlist Duo labels. And we looked at this table previously. And this essentially says that you have to satisfy a certain number of credits in order to reduce the likelihood of runoff from a treated field. And what the table illustrates is the various practices that the agency has evaluated or has listed in this table, and the number of credits associated with each of these practices. Now, some would have a little bit of question on how some of these numbers were basically generated. For example, vegetative filter strips. If we are talking about an application here in Champaign County, Illinois, we're talking about predominantly soils in soil groups C and D. So a 30-foot vegetative buffer on the downslope side of a field, we wouldn't get any credit associated with that. It has to be 100-foot. And for 100-foot, taking 100-foot and putting it into this vegetative buffer, that's only 1 point. So in our soils, we have to satisfy 6 points. If we make only one application, for example, that's 4. If we had a 100-foot vegetative buffer on the downslope, that's 5. We still have to do something else in terms of quantifying or getting up to 6 total points. And the other thing that really is a question that remains, I guess, in my mind, is that what you see circled up here in the orange, it says the land manager and or applicator must effectively implement these measures. And I'm a little bit troubled at that, because that's not really necessarily a one-size-fits-all approach to who actually can be responsible to ensure that these practices are implemented. And we'll talk about this in a little bit. For example, the state of Illinois is a bit, I won't say unique, but perhaps a little bit different than many other states, in the fact that the vast majority of our pesticides are not necessarily applied directly by the person who either owns that ground or farms that ground. So in other words, the farmer, the landowner, is paying someone to make that application. And it seems a little bit far-reaching to assume that the person who is hired to make that application can mandate what these runoff mitigation practices are on any particular field that they're hired to treat. A couple other things I think we can probably expect to see more commonly on labels moving forward would be statements, for example, do not irrigate within 48 hours after application. That, of course, is an attempt to try to minimize the runoff or the erosion potential of the field, but that can be a little bit counterproductive in terms of trying to get good efficacy from, for example, our soil residual products. If we make a surface application of a soil residual product, we really are dependent upon either mechanical incorporation or some type of precipitation to move that product into the soil solution where it will remain effective. If we're actually prohibited for a certain period of time of implementing one of those practices, that could actually potentially result in a lower level of weed control than otherwise we could have achieved if we could have moved that material in by overhead irrigation closer to the application time. There's going to be another statement, very common, I think, on labels moving forward. Do not apply a product when soil is saturated or at field capacity. Makes complete sense. The one that I guess I struggle with a little bit more is the second part of that, when it says, or when a storm event likely to produce runoff from the treated area is forecasted. That, as we've tried to watch our weather forecast in this particular area of Illinois this season, directly because of these kind of statements, is a little bit concern for me, because the accuracy of the forecasts, it's not 100% by any stretch of the imagination. Matter of fact, we've seen forecast earlier in the season where the total precipitation amount over the next 7 days, could potentially cause a runoff effect, but 7 days later, we get hardly any precipitation. So I think that this is something that we're going to have to be aware of, something that hopefully the agency is considering. How can we better define what is meant by these statements about forecasted precipitation totals? And we'll talk more about the Bulletins Live 2 statements here in just a little bit, actually right now. But these are the mechanisms by which the agency is going to present the changes that take place, not necessarily when a new product is renewed, for example, but if there's a change in a product label during the interim period between when the product has been re-registered and the next re-registration period. These, again, are something that we began to look at here in Illinois back in 2020, 2021, with the changes on the re-registered dicamba formulations used in soybean. And the point that I throw up on this slide is that we need to look at these bulletins because they can and they do change. And for example, here for us in Illinois, between 2019 and 2020, there was a total of 27 Illinois counties that were included as counties where the additional downwind buffer and the omnidirectional buffer had to be implemented. In 2021, that was down now to 18 counties. So how do you go from 27 counties down to only 18? Well, in 2021, there were 14 counties that were previously listed that were not listed in 21. And in 21, there were 5 counties that were not listed in 2019, 2020 that were now listed in 2021. And how we see such dramatic changes in these, the total number of counties and the distribution of where these counties are in the state, I'm really not clear on how we can see such a dramatic change in this between about a 1 and 2 year period. And so what do we do moving forward? Well, there's a couple things we really wanted to bring your attention to today. Number one, of course, is something that the agency issued toward the late part of June this year. And this is essentially what they're calling the Vulnerable Species Pilot Project. And so this is a paper that the agency released that identifies mitigation practices for 27 species selected by the agency that they feel like are threatened and endangered. They're calling these the pilot species, of course. And the paper describes how the agency selected the species, how they developed the proposed mitigations and the implementation plan. And the emphasis here is on outdoor uses of conventional pesticides. My understanding is that household uses of pesticides are not necessarily covered in this. Now, of course, the date that this was issued was back in June, and we did want to make you aware of that public comments are due in 2 days. So you can actually go to the government regulations page to get this document. This is what the front page of the document looks like. The draft plan is about 53 total pages. And I included this as more or less an abstract for what this pilot project really is. And you can certainly read this, the Vulnerable Species Project. The agency has identified these species, identified the mechanisms for mitigation, and the implementation that they're proposing to do. And one thing to really, I guess, be aware of is the project is going to focus on these protections for multiple pesticides within a group. Instead of trying to do every individual pesticide, for example, every individual insecticide or every individual fungicide, these mitigations are being proposed that would essentially cover all products in that particular group. And the example the agency is given, for example, the Taylor's checker spot butterfly, would be potentially specific restrictions against the use of all insecticides within or near that species range. Again, I'm not sure. I don't think the agency has specific data for individual insecticides, and certainly not that have been screened against an endangered species. So as a measure of caution, of course, all insecticides could potentially be impacted across or within the species range of this particular butterfly. Now, what you're seeing here, this is the first table of the Vulnerable Species Act that includes the listed species or those species that the agency has selected. And one that's drawn a bit of attention here for us in the state of Illinois is the rusty patch bumblebee. It's an endangered species, and according to U.S. Fish and Wildlife, their assessment of this is that the vulnerability of this species is what they consider high. And so if you follow this document, the agency has done a great job in giving you links to each of these species so you can learn more about what these species are and where their habitat is and what the proposed mitigation practices are going to be. For example, here's the background information about the rusty patch bumblebee. It's a highly social, a fuzzy insect that's a generalist pollinator for many different plant species in the landscape. Often nicknamed the teddy bear of the bee world, so to speak. But I guess that's all okay. But when we look at some of the proposed mitigations around this, I'm not sure a lot of farmers or landowners in this area are going to think about the rusty patch bumblebee as sort of a nice and cuddly teddy bear. So the mitigation measures that the agency is considering and or opposing around the rusty patch bumblebees deal specifically with off-target pesticide drift, as well as runoff. Again, these are going to be the major themes moving forward, these proposals. The two types of mitigation measures that are being discussed, number one would be avoidance, number two would be minimization. And when we talk about avoidance, you can read right here, areas where species is known to occur and application will not be allowed. And so if you look at the distribution map, this is the distribution map of a portion of the range of the rusty patch bumblebee. All the purple hatched areas are known to where this species in the known range of this species. So we're talking a lot about Illinois, the states of Illinois, Wisconsin, and Minnesota. So again, an avoidance area would be an area where no pesticides are being allowed. The minimization area would be around this avoidance area. So an additional protection of a certain number of acres and or feet where applications could not be permitted within these areas. And so now if we look again at the rusty patch bumblebee from table 2 of the document, we see again that Illinois, Minnesota, and Wisconsin are going to be areas that are going to be heavily impacted by this proposed mitigation strategy. Matter of fact, according to the agency estimates, this is going to impact greater than 1 million acres. Now, within that 1 million acres, I'm fairly confident that's not going to be 1 million acres of farm ground, for example, but there's going to be a fair number of acres, of course, where this minimization is going to take effect, where you can't make these applications within roughly a half a mile of where these avoidance areas are. And most recently, the agency has released what they call the draft for endangered species around herbicide use. And again, to try to address the ESA mandates for each individual herbicide that are registered by the agency is something that simply does not have, it's not capable, it's not feasible to try to do that. Now, I will say at the outset, I have not had an opportunity to read all through this document, but I believe the concept of this is that we're going to develop mitigation strategies that most herbicide would fall into, so to speak. So in terms of trying to increase support for farmers, herbicide users, and again, trying to address these things proactively so we don't necessarily have to decide the outcomes of these things in the courts. Now, without surprise, I would say that a lot of what's being proposed is going to be significant changes to how we've actually used pesticides in the past. Now, these are simply comments that the Agricultural Commissioner from North Dakota made. And the only reason I put these up on the screen and share these with you is I think these really capture a lot of the uncertainties from many in production agriculture. You know, we're talking about mitigation measures that we really haven't done before. We're talking about having to do mitigation mitigation measures that potentially are going to impact not hundreds of acres, but literally hundreds of thousands of acres that we may actually have to take out of production in order to meet some of these requirements for meeting runoff mitigation, for example. Now, for those of you who may be interested to learn more about this, the EPA has scheduled a webinar that you can register for that's going to discuss how the agency is going to try to implement this herbicide strategy around the ESA. This is going to be held on August 10th, so you still have time to register for this webinar. And I certainly encourage everyone to register for this, to spend some time trying to understand what all some of the implications and proposals are around the agency's herbicide strategy. And so to get things wrapped up here a little bit, we'll just talk a little bit about the ecological mitigation that the agency has proposed. And a lot of what they're trying to really do is develop these mitigation practices within the auspice of FIFRA. And again, FIFRA is a risk-benefit analysis, so I think it gives the agency a little bit more flexibility in what they can propose to try to reduce the adverse effects of pesticides against endangered species. Now, I won't go through all of this slide, but I really think that what the agency has said is the important point is that the focus of these exposure pathways, what they're going to try to really focus on is trying to reduce pesticide movement by either surface runoff, by soil erosion, or by spray drift. And that's where you're going to start to see a lot of changes on product labels moving forward. You've seen some of these before. These are some of the runoff mitigation for either surface water and or soil erosion. So many of the same things that we showed previously on a couple of slides for the Enlist 1 label, you see some of these obviously listed right here. For spray drift, there'll be more language around droplet size, for example, wind speed, release height, buffers that are going to have to be implemented around either aquatic habitats or conservation areas. And one thing to note, if I understand again correctly, These mitigations will include both public and private lands. And then finally, some additional language that we'll see on these labels, really there'll be an increased focus on pollinators. And for example, what the agency has here listed as a pollinator hazard statement. And I'll show this example here again on the newest Enlist 1 label, where this particular statement now does appear on the label. And one says, it says, do not apply this product to blooming vegetation if bees or other pollinating insects are visiting the treatment area. Again, how we know whether or not they're visiting the treatment area, I'm not really sure how we do that. But because of the concerns around pollinators, the application timing now for Enlist 1 has been set at R1. The original labels, you can actually apply this into the R2 growth stage, but now it says do not apply after R1. That's really nothing to do necessarily with potential residues or crop response, but a lot to do with trying to preserve the pollinators. And then finally, the bulletins to live, these will be the outlet, so to speak, or the mechanism that the agency uses to try to get this new information or changes on labels to the general public. And again, they're going to be considered extensions of the label, so they actually have to be followed according to the laws of FIFRA. And we certainly encourage people to become very familiar with how to access these, how to read these documents, because again, these will be the mechanisms that the agency is going to use to make these changes aware to the end users of pesticides. So I guess in summary, again, a lot of this that we've talked about today is based solely on my understanding. I certainly understand that some of this, I could have misstated something, and if I did, I certainly apologize. But the other thing is these proposals are just that right now. These are proposals. And I would certainly encourage everybody listening, whether it be in Illinois or if you're listening from another state where pesticides are used, I will give the agency immense credit because they do want your feedback. They do want comments made on these proposals. And I do believe they will honestly look at these, the comments that are generated and proposed by the general public and the users. They're looking for input. How feasible will these practices be? Are they not really feasible? Have you an idea for a potential mitigation practice that the agency really hasn't thought of, but yet might be something that could be implemented? So any kind of constructive criticism, any kind of constructive suggestions, I think the agency is going to be very appreciative of those. But some of the questions, I guess, that still linger in my mind is, who again is going to be responsible for implementing these practices? Now, maybe Illinois is a little bit unique compared to other states, but the commercial applicator does not really seem practical if this is the person who simply shows up in the application equipment to make this application. I don't think that this person who's been hired to make the application can go to the farmer in January and say, by golly, if you want me to spray this, you have to do these practices before I can make that application. There's really not a one-size-fits-all approach either for landowners. What do you think? What about if there's a lease agreement? What if it's a 1-year lease agreement between a landlord and a tenant? What if you have an absentee landlord? What if that ground is in a trust? A lot of these questions, I guess, remain unanswered, at least in my mind. And then what metrics will the agency use to measure success or lack of adoption of these mitigation practices? Is simply the adoption, is that the success that we hope for here? And certainly, we have to recognize that pesticides are not the sole agents that could potentially impact threatened or endangered species. There's a lot of other either biotic and or abiotic factors that could potentially impact these species as well. And then, lastly, how are the state regulatory agencies going to handle these investigations? How are they going to try to enforce some of these new provisions on these labels? And again, we talked about this earlier with respect to record keeping. Are there different types of records? Are there going to be new techniques for capturing data during that actual application that applicators are going to find very beneficial in terms of trying to ensure to an investigation that they have followed what the mandates and compliances, that they are in compliance with these pesticide applications? So with that, that's the last actual slide that I had for the presentation. I'd like to thank the Illinois Soybean Association for putting together this webinar today and the opportunity to visit with you on this. And if we have time left, we'll see if we have any questions that we can try to address here.
So Dr. Hager, thank you so much. That was a great presentation. We do have some questions that I'm going to bring up. But before I do, I just want to mention there is one CEU for integrated pest management available for CCAs. You can scan the QR code that's on the screen now to do that, or you can email Connie Copley. So that's CONNIE.COPLEY at ILSoy.org to make sure you get those points. So that said, Dr. Hager, I'll read the first question and you can respond. And then Kyle, if you have anything you want to add from a national perspective, I would invite you to jump in after Aaron. So the first question, are some of these new mandates also occurring in other corn soybean growing states, i.e. Indiana, Ohio, Iowa, etc., or are they specific to Illinois?
Actually, I think anything that the U.S. Environmental Protection Agency, any action or modifications to a label that that agency does applies to anywhere that that product is used. So we use the Illinois example certainly because this is where we've made these had these conversations before. But if there's a statement on a federal label that does not specify that this only applies in a certain geography, the interpretation is it would apply anywhere that that product is used for that particular use purpose.
This is Kyle. I think that's exactly right. And we're having frequent conversations with our colleagues in other states as well who are, their specific crops or commodities or their uses are subject to these requirements as well. In some cases, we actually, I think in the row crop space, have implementation perhaps a little bit easier than some of our colleagues do. I mean, you think, Dr. Hager, the list that he showed of compliance practices, some of them are much more suited for row crop agriculture. You think if you're a tree fruit farmer, for example, in California, you may have a much harder time implementing no-till or cover crops in the middle of your orchard. And so those are some of the struggles that, some of those other producer groups are complying with, but, we're in pretty regular communication with all of them. And to Dr. Hager's point, this is something that would, these requirements would apply everywhere.
Great responses. So the second question or another question we got, does Dr. Hager have a comment on the recent successful farming article about the EPA saying that the neoniconoid seed treatments on corn, soybeans, and other crops is driving hundreds of endangered species towards extinction? I know it's an insecticide, but just curious. So I don't know if you're familiar with the article, but maybe you could start by just kind of defining what a neonicoid or a neonic is for our group and how it's being used. I think probably a lot of us know, but that background.
Again, this coming from a weed scientist, but I believe the neoniconoids, that's an entire class or group of insecticides. Several examples of which I can only name about one or two. Imidacloprid, for example, I believe would be a neoniconoid in that particular class. Again, not speaking from knowledge or experience, I know that there has been some concern about the widespread use of that particular group of insecticides and how toxic they can be to certain species. For example, I believe fairly toxic to bees. That's about as far as I can go because out of complete honesty, I did not see the article in Successful Farming, so I have to claim ignorance on that one.
I think the only thing I would add is that, respectfully, and this is something that we've commented on quite a bit with the agency, we disagree with some of the assumptions that they've used in making some of these determinations. So there is a requirement under the Endangered Species Act as well that you're having to, when you're conducting these assessments, you have to use the best scientific and commercial data available to determine whether or not a species will be affected. And there's some great examples of information that we think are really important for the agency to consider, which we don't really feel that they've done due diligence in doing so. So a great example is that many of us know in row crop agriculture that neonics in corn and soybeans and other row crops are primarily used for seed treatments. And if you're burying a tiny minuscule amount of seed of active ingredient under the ground on a seed, that has a much more limited exposure than, say, if you're doing, say, a broadcast application. And unfortunately, the agency, in their effects determinations and their assumptions, they're assuming that all applications are being made via spray broadcast applications and at much higher rates than we see the usage data reflecting. And so when you're using these very conservative assumptions, the agency is led to believe that that the impacts on some of these species are going to be much higher than we think that they would be if they were using some of that additional scientific and commercial data that they have available to them. So it's there's some regulatory minutia here, but it's something that we continue to try to provide the agency information on, and we hope that they can get to a conclusion that we think is a little bit better supported by what the science and data suggests.
Thanks. And so one other question that just came up for Dr. Hager: will roadside applications be addressed? I see very questionable applications being made along interstates and et cetera. So I think we have to speculate a little bit about what the question's referring to, but maybe you can kind of speak to that a little bit.
And again, this would be my understanding to try to address that question. If it is a product that has a change on that label, then it would have to follow the requirements of that change with respect to ESA, regardless of if it's applied on a roadside or in a field, for example. My understanding is that the only product use pattern that may be exempt from some of these proposed mitigation practices would be homeowner use of pesticides. So for example, what a homeowner may buy at a lawn garden store for controlling ants or flying insects around the house, I don't think those products are going to fall under the umbrella category of what the ESA requirements are. If on the other hand, if somebody's making an application to a roadside, I would assume that would be considered roughly the same as making an application to an aquatic environment, for example. So, and certainly if anybody with the US EPA agencies online, if that's an incorrect statement, please, please provide some clarification.
The only thing I would add is I think that that's exactly right, and that's our interpretation of it as well. Is that, and there are numerous non-agricultural uses, which the agency has stated in some of these documents as well, that would be considered part of, would be required to comply as well. And they've refined some of those lists for available practices that can count towards compliance for many of those uses as well. I think that we do continue to, again, for some of our friends in those spaces and for some of those applications, continue to have concerns, for their the feasibility of some of those options. Is there sufficient number of practices that you can truly implement? But to be sure, the agencies, they seem to have made it pretty clear that they expect that those uses would be need to be in compliance as well.
That's great. So I have one other question that this is actually for me, and this is for both you guys. And I think Dr. Hager, you kind of addressed this when you talked about the herbicide plan, but could you just speak broadly to the timeline of how we expect to see these changes rolled out by the EPA? Thinking in terms of what should farmers be considering in 2024 and maybe after that, for the 5 years after that or something. How should they be planning? How should they be thinking about these things, with the full understanding that a lot of this is still proposed and not implemented?
Well, I think, and Kyle, correct me if your interpretation is different than this, but I would be surprised if we see a lot of whole-scale, widespread changes to herbicide labels going into the 2024 season. We're at the end of the approaching the end of the 2023 growing season in terms of pesticide applications. And of course, the agency comment period for the herbicide use strategy is going to remain open for several additional weeks from this point in time. What potentially could happen if that there is a herbicide that maybe has currently or is undergoing re-registration at this time, if that is a product that the re-registration decision could come for use in the 2024 season. Now that could be potentially a label that would include some sort of, ESA mitigation strategies, but as a whole, group of herbicides specifically for the herbicide strategy, I would think it would be a stretch to think we would see many changes going into 2024. 5 years down the road, quite frankly, I think a lot of the proposals from the agency, it's hard for me to imagine that 5 years from now, the ESA will not impact virtually every pesticide application going forward. It will have an impact in some way or another.
I think that's definitely right regarding the long-term impacts here. I will say just regarding the short to medium-term impacts, to be candid, I think that there's some ambiguity. We're not 100% sure. Regarding for example, the vulnerable species pilot. EPA says in the document that they plan to implement it through the Bulletins Live 2 website that Dr. Hager was showing earlier. And we've heard, and actually there is a lawsuit settlement that EPA has engaged into, and they actually also have open for public comment right now, where they have certain deadlines and dates that they have set by which they plan to finalize, to propose and finalize these various strategies and pilot projects. For the vulnerable species one, they plan to have that implemented or proposed and implemented post haste within the coming months, and potentially even before the 2024 growing season. What we don't really know though is if they're planning on implementing that once they finalize it through Bulletins Live 2, there are some labels out there that reference Bulletin Lives 2, and then there are others that don't. And so would there be a obligation to comply with it if your pesticide label doesn't have a Bulletins Live 2 reference on it? And the answer to that is just, at this time, we just don't really know. We're going to be trying to it's one of a number of things that we're just unsure of, and it seems a little hazy as far as how this is going to practically work as far as implementation is concerned. But I will say, it seems more likely to, what Dr. Hager suggests, that this is something that we'll see take more shape and really start to cement into place, probably more so over the medium and longer term.
All right, so great thoughts, everyone. I appreciate it. In the interest of time, I think we're going to go ahead and cut it off. We're about 2 minutes over our 11 o'clock time period. I do want to remind everyone that if you have additional questions, you can definitely email Illinois Soybean, or you can email Dr. Hager directly at hager@illinois.edu with questions. And again, please make sure you get your CEUs credits by either scanning the QR code or emailing Connie Copley at ilsoy.org. And at that, I think we'll finish it. Thank you very much, guys.